The Safety Act sparking all kinds of controversy in recent weeks and months as we head towards the November 8th general midterm election. But the Safety Act actually passed back in January of 2021. And here we are in October of 2022. What is the Safety Act? It's a pretty broad measure that impacts police regulations and criminal justice. And it came in the aftermath of the murder of George Floyd, and a lot of activity trying to, in a way, bring about more equity, a term that's used by policymakers to make things more equal across economics and criminal justice and business and so on. But the Safety Act is a pretty broad sweeping bill that, among other things, eliminates cash bail for certain offenses, meaning if you're arrested and you'll get processed through the local jail, but you won't sit in jail, you'll be released pending trial. So there's a lot of significant changes that law enforcement have actually said they need to have happen before its implementation January 1st. We've been following this, of course, with Springfield's Morning News for months, even back when it first passed in January of 2021. But again, as we get closer to its implementation and more states' attorneys are taking a look at the clear language of the law, there's significant concerns. We'll hear some of those concerns, but real quick, a phone call. Good morning. You're on WMAY.
Greg, it goes both ways on like the political campaign commercials. There is no purge, right? They're not going to open the gates January 1st. Like the prisons aren't going to just release.
There are still some states' attorneys that, from their interpretation of that, that's how they interpret it, that people they have behind bars right now pending trial could be released. Gotcha. So that's
now,
still a concern.
What my question is, because I know the judge has the ultimate say in the end, so will they go back to the prosecuting judge, the sitting judge of that case? Like, hey, we've got Emilio over here. We're going to let him out. What do you think? Is that how that's going to work or what?
And again, I think that there's this caveat of 48 hours prosecutors have to prove to a judge that somebody's either a flight risk or a danger to the community or so on. And prosecutors have said 48 hours is not enough time to get the necessary information they need.
I know you got to go, but what a pain in the butt that's going to be if you've got to look at each case and each defendant that's going to be let out, and now you've got to go track down the judge that was doing, that initially put him in jail, and go, hey, what do you think? Let him out? What do you think? Flip a coin? What are we going to do?
Well, and that's the concern. And that's the concern prosecutors have raised, is it's not clear enough as to what exactly is going to happen. I appreciate the call on that. And that really helps kind of crystallize some of what's going on here, right? Yeah, is it politics? I don't know. But let's hear some of what Governor J.B. Pritzker had to say about this issue recently when he was asked. Again, he was asked multiple times during the debate Thursday, what specific changes would he like to see? Because the lawsuits that states' attorneys are filing are stacking up. Even in Sangamon County, Dan Wright's filed a lawsuit to block the implementation of this, saying that it's unconstitutional for several reasons. But here's Governor J.B. Pritzker on Friday talking, again, answering the question, what specific changes would you like to see? And he doesn't really provide those real clear specifics.
Well, I think it's very important that we look at Senator Scott Bennett's bill. He's really, I think, written a pretty good bill, the provisions of which we should go through and decide which ones are appropriate. Working together in committee hearings and working groups, there are appropriate changes to make, most especially to clarify for everyone that there's no such thing as a non-detainable offense. And that what we're aiming at here is keeping murderers and rapists and domestic abusers in jail and not keeping people who can't afford bail for a nonviolent offense out of jail, not putting them in jail, but rather allowing them to get out of jail.
So it seems that they might try to reform the language in the bill they passed in the final hours of the previous General Assembly to make it so it's nonviolent crimes. Because as it is right now, Sangamon County State's Attorney Dan Wright, he said in a statement when he filed the lawsuit challenging the act's constitutionality for various reasons. He said in a statement, the law takes effect January 1st, contains confusing and inconsistent provisions likely resulting in divergent interpretations and disparate outcomes across the state. Other measures are clear, he said, but raise sincerely held public safety concerns. Continuing on here with what Dan Wright had to say, again, Sangamon County State's Attorney, he said offenses which are truly not detainable under the act include misdemeanor offenses and Class 4 felonies, not specifically listed in the plain language. These offenses include, among others, aggravated DUI causing bodily harm, certain hate crime offenses, aggravated assault with a firearm, concealment of death, and threats of violence against persons at school. Wright said January 1st, judges will no longer have discretion to assess danger to the community as a whole when considering pretrial detention of individuals charged with broad range of violent and dangerous offenses. He goes on to say, listing these offenses: aggravated battery, including great bodily harm or permanent disfigurement, aggravated DUI, fatality, aggravated fleeing and eluding a peace officer, aggravated leaving a scene of an accident, great bodily harm or death, arson, burglary, drug-induced homicide, intimidation, including threats against witnesses and potential jurors, kidnapping, robbery, second-degree murder, threatening a public official, possession of a firearm by a gang member, possession of a stolen firearm, concealment of a homicidal death, theft in any amount, and all offenses involving legal drug distribution, Wright said. Similar charges to Wright's allegations in the lawsuits have been filed by state's attorneys across the state, including in Madison County, Knox County, Winnebago County, Boone, Henry, McHenry, and Will counties, all filing lawsuits to try to block the implementation of the Safety Act. We do have, as Governor Pritzker mentioned there, Scott Bennett's bill, a Democrat out of Champaign in the state Senate. And that bill, it's been filed. We haven't seen any public hearings on this yet. But the act takes effect January 1st. I don't expect lawmakers to come back in these weeks leading up to the election, but they are scheduled back the week after the election. So I imagine you're going to see a lot of the conversation on this heat up even more. And what's fascinating is the election could very well dictate which track they take, right? Do Democrats have their rear end handed to them in the election out of concerns of crime and so on, and that causes them to recalibrate? Or if they come out of the election with their supermajority intact, do they then just move forward and provide very surface level changes? These are all things we have yet to see. Of course, it's going to be a fascinating next few weeks here once we get to the election, after the election, and as the General Assembly reconvenes for fall veto session. So we'll keep a close eye on all of that here with Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News.